Well, thank you everybody for coming, and to those who are live streaming, and my understanding is there are quite a few. Thank you for joining us via live stream to Cybersecurity in the Marketplace. For those of you who have not been to our prior workshops, this is the third and final of our workshops. The first one was Cybersecurity in the Boardroom, where we talked about C-suite level, board level issues for cybersecurity. Our second program was Cybersecurity in the Trenches, which was a little bit more operational in perspective, where we talked about the how-tos of dealing with the requirements for cybersecurity. And we had some great experts on both of those conferences to help out. And today is the third in the workshops, and we're going to talk about the insurance marketplace. And this is sort of the third leg of the stool, where you have prevention, where you have operations, and now this is where you have some protection. And for those of you who are aware of the marketplace, what you know is there are no standard policies right now. Everything is manuscripted, and we're fortunate enough to have Emily Lowe from Willis Towers Watson, who's going to give us an extended discussion of what the marketplace looks like, what's going on, considerations that people should be thinking about, whether you're underwriting insurance or whether you're buying insurance. So I think it's going to be a great program today, very informative. As with all of our programs, we would like this to be interactive. So please feel free to ask questions if you have questions. And if you have some input that would be helpful, please feel free on that. I think, Kara, do we have microphones just in case? Okay. So I would encourage you to participate. Don't wait to the end. Don't forget your questions. And those of you who are live streaming, please send in your questions, and they'll be relayed to us up in the front. Unlike the prior two workshops, I don't have to say anything substantive today. And so for those of you who know me, my name is Jim Gunnis. I'm program chair for this workshop, and I get to set the stage for what the others are going to talk about. So with that, actually one housekeeping matter I'm going to tell you now. I'm going to remind you again at the end. There are CLE, CPE sign-up sheets over here against the wall. For those of you who are here and want CLE credit or CPE credit, please make sure you sign in. I think that's particularly important for New Jersey people who have to sign in to get it. Pennsylvania, you have a form to fill out and give it back to us so you can get your CLE credit. So anyway, without further ado, cybersecurity in the marketplace. So like I said, I have the pleasure today of not saying anything really substantive, of being able to get to pose the question and have everybody else answer it. So, I'm feeling very relaxed. I thought we would start today where we started our first one, and so we're kind of coming full circle. Just kind of a pictorial list of some of the more notable cyber attacks. Obviously Sony, Target, Starbucks, the eagle there is the Federal Republic of Germany. Of course, Philadelphia City Council, always enjoy that one. Home Depot, the White House, it's always a good one. Anthem, we'll talk about that. Here's some 2016 cyber attacks, some of which you've heard of, some of which we talked about before. Dyn, the one over there all the way on the right, is an interesting one because Dyn is a sort of a computer way station for the internet. It's a middleman. And what the hackers were able to do was to overload their computers with the use of cameras and DVD players. So it wasn't computers doing the hacking, it was actually the camera that's on your computer or hanging over your computer screen and DVD players. They just overloaded it and caused a disruption in the internet. So of course Yahoo Everybody knows that. Just some facts to sort of remind you of why we're here today talking about those things. By 2021, the FBI is saying cybercrime damage is going to reach $6 trillion per year, which is obviously a massive number. Ransomware, and of course we just heard about ransomware just last week with all the hospitals across Europe and into Asia suffering ransomware attacks. In 2016, there were 4,000 ransomware attacks a day, according to the FBI. One every 40 seconds, according to Kaspersky. There were, in the third quarter of 2016, there were 18 million new malware samples. So this is the volume of this stuff that's just being thrown at everyone, whether it's individuals or companies, day after day after day after day. Now, on the other hand, when you compare the 6 trillion annual number by 2021, in that same period, the cybersecurity spending is only $1 trillion. So you can see that the damage is going to significantly outweigh the amount of money that people are spending for security. And we're going to talk about damage and companies' experience with damage in a minute. In 2015, there was an Association of Corporate Counsel study, and 25% of the chief legal officers who were questioned said that they had experienced a data breach. Yet only 1 in 3 of those in 2015 actually had cyber insurance. I'm not going to steal, God bless you. I'm not going to steal Emily's thunder here. But I did want to just talk about this for 30 seconds or so. There was a Cambridge Business School study that looked at what kinds of insurance were out there, how was it being implemented. And the study said there is standalone cyber cover, which you buy separately. You can get an endorsement to an existing policy for certain kinds of coverage. There are gaps in exclusions in your CGL policies, and Joel's going to talk about that. And then there's what they call silent cyber exposure, which I think is just everything that's left over that you might be able to find a place for. What I thought was particularly interesting about this study was that they found that there were 35 insurers offering 26 different insurance products. But when you look at what those insurance products are covering, they don't cover everything that you would think they would cover or that you might want to have covered. So 81% only covered incident response costs. 69% covered business interruption. 62% only offered regulatory and defense coverage, and only 13% offered D&O coverage. So, and as you'll see when we talk about some of the specific instances, what happened to some of the Ds and Os, you know, the fact that there's only 13% coverage, at least in what the Cambridge Business School looked at, is a very low number. So like I said, I get to set the stage today. I get to talk about what has this cost companies, and others get to talk about how do you get coverage or not coverage, as the case may be, and what kind of coverage is out there. So these are a few of the more recent, more notable cyber attacks. And we went back and looked at to see how much we could find about what did it cost them, what did they spend, what were the results of it. So Home Depot, $292 million as of 1/1/17, and that number is still climbing. That's not a final number. They had $100 million of insurance coverage with a $10 million deductible, which they've exhausted, by the way. They spent $134.5 million to credit card companies who sued them for the damage to their customers. They spent $25 million to banks who sued Home Depot for damage to them and to their customers. They spent $19.5 million to settle a class action suit for consumers who sued them for additional expense above and beyond credit card losses. But at Home Depot, there was no executive job loss. Target, and by the way, if you look at these numbers, they're remarkably similar. Home Depot, 292 million. As of 12/31/16, Target, 291 million. It's just a coincidence, I think, but it gives you a sense of some of the consistency of the magnitude for these kinds of companies. Again, Target had $100 million of insurance with $10 million, a $10 million deductible, and Emily may be able to give us an idea whether that's sort of standard or coincidental or what. In this case, both the CEO and the senior technical officer resigned as a result of this breach. And they were forced to resign. It was not voluntary. Give you a little idea of the spending of that $291 million. In 2013, they spent $61 million, for which they got $41 million back in coverage. And in 2014, $191 million with $46 million of insurance coverage returned to them. Yahoo. There's no public data out there on what they've actually spent, but the number that's probably the most important number is Verizon was in discussions, in serious discussions with Yahoo about buying them. And the original purchase price was going to be $4.8 billion for Yahoo. After the breach was disclosed, Verizon said, all right, well, we're not buying you for $4.8 million anymore. We're buying you for $4.45 billion. So $350 million was reduced from the purchase price by Verizon to account for what they thought was going to be the total cost of the loss. The CEO retained her job, but she lost a $2 million bonus, plus she was entitled to equity every year. She lost her equity component of her bonus as well. And for all of you general counsels out there, the general counsel took a hit for this one and was forced to resign. So Dave?
I'm not going down.
Okay. Not without a fight, right? But you can see that you can see there's collateral damage to this as well. Now, interestingly, I was looking as we were going through these for stock price injury, reporting of reduced profits and losses, and it seems like, and there's no consistency to this, and Emily, you probably have better knowledge of this than I do, since some of the coverages you write are intended to cover these things. It seems like there is very little damage to either stock price. It seems like there's a dip in business right after the breach, but it seems to come back. So all these companies reported that basically they had no significant business interruption losses, they had no significant business losses, and no significant loss in stock price, which is interesting. Anthem. Of course, Anthem is a blue, bit different company. But Anthem spent $260 million in improvements and remediations. They're one of the few where we actually get to see what they actually spent on. So $2.5 million just in consultants. So those are your IT consultants. Those are your consultants who are helping you deal with disclosures and your breach issues and regulatory issues. Lawyers are probably included within that. $115 million just on security improvements, just to correct the problems that were endemic at Anthem that allowed them to be hacked. You can see the cost for the initial notice to go out to all of their customers and consumers, and it was $31 million just for notice, just initial notice. $112 million for credit protection for their customers. And then they got fined $415,000, and those are the only regulatory fines we could find. There may have been others, but those are the only ones we could actually find that were reported. the Office of Personnel Management, federal government. Both the head of the Office of Personnel Management and the Chief Information Officer both resigned. The director first, and more reluctantly, the CIO a little bit later. The only disclosure that's been made about the Office of Personnel Management was that they paid $130 million in identity theft protection. We don't know how much they spent to upgrade systems, assuming they upgraded systems at all, but I would assume that they did. Beyond the $130 million, there's no disclosures from the federal government, which of course is supposed to be transparent and open, and we should be knowing what's going on, but we don't. Sony, the PlayStation hack. As you know, there were 2 Sony hacks, and we'll talk about the second one in a minute. The first one was the PlayStation hack. And Sony has reported in its financial statements that they spent $171 million for the PlayStation hack, which was comprised of identity theft insurance, improvements to the network security, free content. They agreed to give their customers who were impacted by that additional Sony games and things, and that's included in that. Customer support and investigation costs. They also settled a class action for $17.5 million, and they were fined in the UK $400,000. Second Sony hack, the films hack, probably the one we're most familiar with because it was the one that was probably the most publicized. Of course, North Korea hacked Sony, was trying to prevent the release of the films, which, by the way, for any of you who are Pirates of the Caribbean fans, I don't know if you have heard, but hackers claim to have the new Pirates of the Caribbean movie and have demanded ransom from Disney. Otherwise, they're going to release it. And for those of you who are Orange is the New Black fans, last year, hackers got, I think, 8 or 9 of the episodes and attempted to extort money from, what is it, Netflix or whoever it is that does that. Netflix refused, and they published them in the public. So you may get a free shot at Pirates of the Caribbean soon. So, but the Sony Films hack, surprisingly for the one that got all of that publicity, only $35 million in improving their financial and IT systems, and only $15 million in investigations and remediation costs, which is surprisingly low. And again, nobody lost their jobs. TJ Maxx, for those of you who are Maxistas. 2007, they got hacked. They estimated shortly after disclosure of the hack that it was going to cost them $25 million. You can see what it has actually cost them. As of 2017, their expense to date, $256 million. So they're off by a factor of 10. 2007, they spent $118 million, mostly notification cost. 2008, $107 million. 2009, $21 million. And then they ultimately settled a lawsuit with Visa over their credit card holders and the disclosure of that information for $41 million. So you can see that you can see the difference between what their initial estimates were of $25 million and what they ultimately have paid. And again, this is a cost that isn't done yet. So what do we learn from all of this? What kinds of costs are things that if you get hacked or your company gets hacked, you should be thinking about? Well, obviously system improvements and repair. Notification costs. We saw how big some of those notification costs were for some of those companies, $118 million, I think, for TJ Maxx as an example. Credit protection for consumers. Investigation, consultants, lawyers, just on the breach side. Then there are lawsuits, banks, consumers, credit card companies. You have regulatory fine, and in the case of Yahoo, where we saw a $350 million loss of acquisition value. So these are just some of the things that could be impacted as a result of a breach. So like I said earlier, I have the great pleasure of being able to set the stage, to ask the question, and then leave, which is what I'm going to do right now. So with that, I'd like to introduce Joel Hopkins, a partner in our Harrisburg office. Joel is a specialist regulatory lawyer who deals with insurance coverage issues, who deals with the insurance department frequently on all kinds of issues. And Joel's going to talk to us about CGL policies and cyber coverage. Joel?
Thank you, Jim. I do have to correct something Jim said. You're not going to have access to the Pirates of the Caribbean movie because that would be illegal. So there, free legal advice. Don't access if it comes out early. Listening to Jim, obviously, the risks here are huge. They are substantial. The numbers are staggering. And you're going to hear Robert and Emily are going to talk about a lot of the coverages that are out there that are designed to deal with this type of risk, specifically designed for this type of risk. I'm going to talk about those that aren't specifically designed for this type of risk. And if you're asking yourself, well, why are you talking to us about coverages that aren't designed for this type of risk? The reason is that the vast majority of companies, particularly I would guess, and maybe Robert or Emily will have an opinion, I would guess typically the smaller, mid-sized, smaller companies aren't out purchasing the types of coverages that you're going to hear Emily talk about. And that leaves them with essentially what's in their standard array of policies. And although that is not an excuse to not go out and buy policies to deal with these types of risks that Jim had talked about, these tremendous risks, it is nonetheless a resource if and when something happens and the cyber policies aren't in place. I'm going to talk a little bit about 4 different coverages, and I'll get there in a second, but it's interesting when you think about how coverage and this risk has evolved. The first real cyber attack in the United States came in 1988, I think. It was called the Morris worm, and I couldn't speak to exactly what that was, but nonetheless, it's kind of recognized as the real first extensive cyber attack. Well, the commercial general liability policy that I'm going to speak a little bit about first came out in 1940. The first version was in 1940. And there have been multiple versions of it since 1940. But nonetheless, when you read the very first version all the way to the last, there's a lot of similarity. This is not a product that's designed, certainly, or could have ever anticipated the types of risks we have here. The commercial property policy that I'm going to talk about, ISO, that came in 1940. And yes, it has evolved, and yes, it has changed, and we'll talk about some places where it's actually tried to respond to these types of risks. But in large part, this is not a coverage that would have ever anticipated the types of risks we're seeing here. The fact, though, is that they can't be ignored. They can't be ignored because, as I said, a lot of companies will not have specific cyber policies. Jim pointed out how a lot of those coverages don't respond to all of the different risks. And sometimes your clients, your companies are going to be left to looking at these traditional policies to see where and whether there might be coverage. Now these are, I want to talk primarily about the 4 you see listed there, but that doesn't mean there aren't others. There could be, for example, a lot of medical professional liability policies actually carry a high-tech endorsement on them that responds to certain High-Tech Act claims. So there are others. But I think what we have here are the 4 that if I was a general counsel or I was a COO and my company faced the types of exposures that Jim talked about, and I didn't have a specific cyber policy, this is where I would start my mad scramble to say, what do I have? What possibly might respond to these types of risks? The directors and officers and errors and omissions are probably, and by the way, I kept general liability for the last, but I think the D&O, E&O are probably the first place I would look if I'm dusting off the insurance portfolio after a loss. And let me give you a quick overview of D&O and E&O insurance. Essentially, D&O insurance has three aspects to it. It covers the individual directors and officers when they get sued for a breach of their duties. It also covers the company when the company has to indemnify or reimburse an individual director or officer when they face liability. The first coverage is called Side A. Second one, the indemnification from the company indemnification, is called Side B. And then a lot of policies also have what's called Side C coverage. Side C coverage covers the entity itself, if the company, the entity, is actually named in a lawsuit. E&O policies, errors and omissions, are professional liability policies. The common thread between a D&O and an E&O policy is that they both respond to loss arising from a wrongful act. That's kind of the general structure of a D&O and an E&O policy. And a wrongful act is defined typically as an act, error, or omission within the scope and course of your duties as a director or officer or a professional, if you're talking about an E&O policy. And that is a very broad grant of coverage. When you read a D&O or an E&O policy and you look at the definition of a wrongful act, you say, wow, an act, error, or omission within the course and scope of being a director, that's a lot of stuff. And it is. It's very broad. Now, like every insurance policy, there are always exclusions that narrow it. But D&O policies have been called into play in connection with cyber breaches now for many years, and successfully for many years. And the reason is because the types of claims that can come out of a cyber breach really can touch the individual Ds and Os and the individuals who are running the company, and those claims oftentimes fit pretty squarely into a D&O policy. Let's talk just very quickly about what some of those claims are. Breach of fiduciary duties by directors and officers. If any of you were tied into the prior portions of this series, you would know that directors and officers have extensive oversight responsibilities when it comes to the security, the cybersecurity of the company. In the insurance world where I work, the directors and officers have regulatory responsibilities that make them responsible for that oversight. And when you have a breach, or when a breach occurs, one of the very common claims is that the directors and officers breached those fiduciary duties with respect to the oversight of the security, the cybersecurity of the company, and as a result, the breach was allowed to occur. And that is, there have been many cases, and there have been many claims where D&O policies respond to those specific types of claims. Another one is a waste of corporate assets, and that's essentially as the directors and officers management failed to protect the company in a way that the company now had to spend a ton of money that it shouldn't have on, as Jim said, on the professionals, on the evaluations, on all of the things in responding to these types of losses. So a claim for a waste of corporate assets, a typical claim, is something that is oftentimes covered by a D&O policy. Derivative actions by shareholders for mismanagement of the company, mismanaging in failure to perform your duties with respect to the cybersecurity of the company. So those first three are all claims that would typically be made against the individual directors and officers. And a D&O policy will likely respond to this, or may respond to this. Jim had mentioned the Target breach. The Target breach had, the claims included waste. It was a derivative action. It It named the CEO, the CFO, the CIO, the individual directors, and the D&O policies were implicated there. Again, I don't want to say a D&O policy should be a first line of defense. Remember, I'm talking about kind of the fallbacks when you don't have anything else, but always a place to look for coverage. The fourth point down there, claims against the company, that's where side C coverage exists, and there's a specific claim saying that the company ultimately breached its duties and was responsible for a loss. Breach of professional responsibilities leading to a cyber incident. E&O policies, professional liability policies, people who work in this world, and if they are implicated for failing to do something they should have done in a professional capacity that leads to a breach, PL policies might apply there. And I do want to put a word of caution out here. As I said, D&O and E&O policies, the grant of coverage is pretty broad, but be careful, because the insurers, the D&O and E&O insurers, are recognizing that, hey, our policies are getting, perhaps inadvertently implicated, and we don't want that. So we are starting to see exclusions pop up that specifically apply to cyber breaches. Kind of the converse of that, there are also carriers who are offering essentially tag-on cyber liability coverages on the D&O policies. They do it by endorsement. It typically doesn't carry the same limits that go along with the rest of the policy. It might have a larger deductible, but I've actually talked and I've worked with clients, and we've talked about their insurance programs, and I've had clients, generally smaller clients, who say, you know what, I'm going to do that, and I'm going to cross my fingers and hope I don't actually have a breach. But they use this as really their primary source of coverage. Again, I don't recommend that, but sometimes smaller companies take that course. Property policies. This is another source of potential coverage whenever there's a cyber breach. Think of a property policy simply as a policy that responds to first-party losses. That means losses that the company sustains itself. I'm going to make some very broad generalizations here, but typically property policies respond to direct physical loss or damage to covered property. So in the very basic concept, I own a wall, my wall gets damaged because of some sort of covered peril, something falls over and hits it. It's direct physical damage to that covered property. As you can imagine, in the cyber world, you probably are sitting there going, well, what in the world does that have to do with a breach, a potential cybersecurity breach? And where on earth would you have direct physical loss or damage to covered property? Well, there are lots of cases that interpret this coverage in a cyber breach context. For example, cases that say the physical alteration of data and systems constitutes direct physical loss or damage to that property. Computer systems, the data that's held on that property. Theft of data. I am not a techie by any means, and anytime I try to talk about things computer, both of my kids laugh at me. But the cases, several of the cases suggest that if you've got data on a system, on a tape, on a hard drive or something like that, and somebody comes and takes it, that system has been physically altered, and that physical alteration constitutes direct physical loss or damage. So one of the things, the first layer of looking for coverage under a property policy is, has something been taken from the insured? Has somebody reached into the insured, into their pocket? Have they made a change? Have they done something that could arguably be direct physical loss or damage? There's also coverage for business interruption and extra expense. And This is a coverage where let's say there's been a hacking event, and as a result of the hacking event, the business has to shut down. It's lost its data, it has to shut the computers down, as we just saw, I guess, a week or two ago. Computer systems have to be shut down while things are done to deal with the cyber attack. Well, business interruption and extra expense coverage says, okay, we understand that when that happens, you are going to lose income, that your business has been interrupted, and the property policies in some cases will have coverage that responds to that by replacing that lost income or the extra expense costs that were incurred as a result. And the case I've cited here, the NMS Services case, this is a case out of the Fourth Circuit where there was coverage, an employee hacking and erasing of files. So you had two things going on here. You had an employee who got in, erased files, and they found that there was direct physical loss or damage. The files were taken. And as a result, there was a substantial business interruption, the substantial loss of income, and that was ultimately determined to be covered. So that is a second place to always look under a property policy for potential coverage. And then contingent business interruption coverage. This is one that every time I talk to policyholders, or if I'm working on behalf of companies, this is one that I think a lot of people don't. It's not kind of first on your mind. What a contingent business interruption coverage is let's say I rely on Jim's business to make my business run. Jim gets hacked. Jim shuts down his systems. I'm now dead in the water, and I can't work because Jim's not up and running. So I am now suffering a business interruption based on Jim suffering business interruption. And this type of coverage oftentimes, as long as the loss comes from a covered peril, as long as you have that direct physical loss or damage to Jim's property, if it results in me losing business, I might have a claim under the contingent business interruption coverage. I had mentioned earlier about endorsements, and it's funny, a lot of carriers, as the cyber exposures were starting to really bubble up to the top and they were becoming part of kind of the everyday parlance, a lot of carriers came up with endorsements, sometimes to take away coverage, sometimes to give a little bit. The ISO endorsement, the BPO 595, this is an endorsement that goes on to what's called a BOP policy, and this is a liability coverage, but it's limited coverage for direct damage to data due to the insured's negligence. So the reason I threw that in here is really just as another example. Sometimes your mind automatically goes, oh, this would never be covered by a property policy. Or you read through the property policy, or you look at the law of your jurisdiction, you say, no, I'm sorry, the Third Circuit doesn't declare a theft of data to be direct physical loss or damage. Don't forget to look for these endorsements. Sometimes they are placed on the policies, and they've been there for a very long time, and they can offer a degree of coverage when there's a cyber risk. Crime and fidelity policies. These are also typically first-party policies. A fidelity policy or a fidelity bond can have a third-party component to it, but let's think about it right now in a first-party context. These are policies that typically respond when somebody the insured has been the victim of a crime, when somebody has had something taken from them. And the Retail Ventures, that was the DSW Shoe Warehouse. I think that was the operating arm of Retail Ventures. And this was a case that was decided under Ohio law, and it involved a blanket crime policy, and it had a computer fraud rider on it, essentially an endorsement that provided a little bit of coverage in this case. And what happened here is it was a theft of credit card and checking account information. It involved about 1.4, 1.5 million customers. And it was ultimately determined that the policy covered loss directly resulting from the theft of any insured property. Initially, when this case came in, the insurer had denied coverage and said the loss wasn't the direct result of theft. Because a lot of the costs and the dollars that were being claimed in this case involved things like costs to investigate, to provide notice, to hire a public relations company to deal with the aftermath of the cyber breach. And the insurer said, no, I'm sorry, that's not the direct result of theft. The court said, no, approximate cause standard applies, and ultimately these costs were covered. I like and I've talked in the past about the Retail Ventures case, not so much to say, hey, look, here's the magic arrow that says the crime and fidelity policies will respond. But I like it more because what it does, one, it involves a crime policy, so it demonstrates that there could be coverage under these type of policies. But the thing I've always found interesting about this case is the court did, perhaps some would argue, a little bit of mental gymnastics to find coverage under this policy. And that is because, well, in my opinion, that's because the court looked at this and said, even though the policy may not have been necessarily designed for this type of loss, when I look at the language, we look at the four corners, we evaluate it in light of the facts, yeah, you know what, it looks like it fits. So kind of the takeaway there is you should always be looking at these policies to see if they potentially respond to these types of losses. So with that, let's get to the commercial general liability policies. As I said earlier, these are really, these are absolutely not designed for cyber risks unless there's an endorsement put into place. That is just not what these are for. And I don't want to belabor, and I hope this isn't too elementary for a pretty sophisticated crowd, but as a quick reminder, commercial general liability has several different coverages, including Coverage A. Coverage A responds to claims for bodily injury and property damage arising out of an occurrence. So if you think about a situation, and also remember that a commercial general liability policy is a liability policy, so it responds to claims brought by third parties for a liability that might fall on the insured. Courts have very often held that the loss of electronic data is not property damage. And now if you think about, if you were awake earlier when I was talking about in other contexts, you might go, how does that make any sense? That under a CGL it doesn't constitute property damage, but under a property policy, I thought I heard this guy say that it might. It has a lot to do with the different language that's being used in the two policies. In this case, the definition of property damage often requires the property to be tangible, which electronic data oftentimes is not. Now, think back to what we talked about under the property coverage, and there's certainly a lot of similarities there. I will tell you that the answer, courts all over the country, the answers are all over the place. Some courts are saying, yes, that is property damage, tangible property, the loss of data, the loss of information, the stealing of that does constitute property damage. Other courts say, nope, don't see it that way, and electronic data is not something tangible that can be touched, and therefore it doesn't fall within the scope of the property damage. The other thing to remember under GL, under Coverage A, is a lot of policies have an electronic data exclusion that precludes coverage for losses from a loss of data, loss of use of data, damage to or corruption of data, inability to access or manipulate data. This is something that CGL carriers, when they realized there were courts in this country that were some that were interpreting the coverage A to actually apply, some that were not, carriers said, okay, let's button this down and let's put an exclusion in place that really ends all of the debate over whether this is covered. I'm not here to tell anyone if you're looking for coverage potentially under a CGL, I'm not here to tell you to give up. I'm here to tell you to be mindful that under coverage A, it is a difficult proposition to find that coverage. Now, the good news / bad news is the CGL doesn't stop there. It's also got a coverage B. And a coverage B is for typically what's called personal and advertising injury. And coverage B covers amounts the insured becomes legally obligated to pay as damages because of personal and advertising injury. And personal and advertising injury is defined to include publication of material that violates a person's right of privacy. The vast majority of the cases that are interpreting coverage under a CGL policy for a cyber breach are focused on coverage B. And the vast majority of those cases are looking at the issues, is there a publication and is there a violation of privacy rights? And that certainly goes directly to the definition. And perhaps this is why we have cyber specialty coverages. The decisions are all over the place, and I mean literally all over the place. You can look, you could read, we could talk for hours if anybody was so inclined as to all the different cases and all the different analyses and all the different conclusions, and you would not find an answer in any of them. You would find interpretations, and you would find that they are as inconsistent as the facts that underlie the cases. I do want to talk about a couple here just to kind of tee up some of the issues that the courts have dealt with and give us a little bit of focus as to where they ended up. The Netscape case, that was AOL intercepted and disseminated private online communications. And there was a putative class action lawsuits based on that software and the allegation that AOL grabbing that information and disseminating the online communications violated the user's privacy rights. In that case, the court found that there was coverage under the CGL coverage B. And essentially what the court said in the Netscape case is that they had grabbed the information that they didn't have a right to, that having that information constituted a publication because somebody had it who shouldn't have had it. And it also said that it violated the user's privacy. The court said that taking that information violated the user's privacy rights because the users had a reasonable expectation that that information would have remained confidential, would not be disclosed or taken by AOL in this case. And even though that, and the fact that that occurred was sufficient for the court to say that there was a publication and that there was a violation of privacy rights. Interesting thing about Netscape is, if I'm recalling that one correctly, the court didn't delve too much into the specific facts. What information did you take about Joel? Who read it? Who accessed it? How many times did they access it? Do they now know something about Joel that they wouldn't have known before? Instead, the court really looked at this and said the fact that Joel's information was intercepted and it was communicated by AOL was sufficient to constitute a violation of the individual's privacy rights. So in that case, there was coverage. In the recall total information case, This one interests me just by the facts. I know we've heard other people talk about somebody leaves a laptop on the train, and quite frankly, that doesn't surprise me. I've almost done it myself a couple times. But this one was, there were tapes that were on the back of a truck, and the tapes actually fell off the back of the truck and were picked up and taken. And these tapes had certain private, data and information on it. That one just strikes me because I picture a truck driving down the street and the box falling off the back and someone going, aha, secret private tapes, let's go see what's on them. In that case, the court said publication was required to trigger the CGL coverage. And what the court did is kind of a little bit different than Netscape. The court went a little bit deeper and said, you've got to show me that somebody actually accessed this information in order to have a publication. It's not enough just to put the fact that the information was out there and that somebody else had access to it, or someone could have accessed it, but you've got to demonstrate that there was a publication, i.e. that somebody else accessed the information before the CGL coverage is triggered. And because the plaintiffs, in this case the insureds, could not demonstrate any facts to show who took the tapes and who did what with the tapes, the court said, sorry, we don't see that there's been any publication. So in recall, there was no coverage. And then in the Zurich, this involves the Sony breach. And in that case, the court said that hacking constitutes publication, but not by the hacked party. And let me explain that, because every time I read it, I go, well, what does that even mean? The policy requires, if you go back, personal and advertising injury, I didn't have the full definition, defined to include publication of material. The policy in Zurich requires the publication to be by the party who's getting sued, because the allegation is that the insured wrongfully published material and somebody else had access to it, and therefore it constituted an invasion of privacy. So in this case, the court said Sony didn't publish the material, the hacker did. The hacker is the bad guy. Now, that's, to me, in the insurance coverage world, that's crazy for a couple of reasons. But nonetheless, it's up here to demonstrate, a court's reasoning that hacking equals publication, but not publication by the insured. I think the result would have been completely different here if the allegations against Sony were a little bit different. If the allegations were that Sony didn't have proper protections in place to prevent the publication, I think we would have seen a very different result. But nonetheless, kind of an interesting decision on the CGL. Hartford is a case that's a little bit opposite of Sony. In that case, said hacking is publication by the hacked party and statutory damages were recovered. This was a California case, 2013. And again, not saying right or wrong, the real point is to demonstrate how the cases are all over the place on CGL policies. But it strikes me, if you ever read these cases in order, and you read one and you say, okay, I think I got it. I think I know how this all works. You read the next one and you go, okay, I'm completely confused again because this, the pendulum just swung the other way. But nonetheless, in Hartford, the court said hacking is publication by the party who was hacked. Travelers Portal Healthcare Systems. This is a case where there was unintentional patient data breach. Records were not viewed by a third party. And the insurer in that case says, well, wait a second, if somebody didn't view it, it cannot have been published, and therefore this shouldn't be covered under coverage B. The court found that there was coverage, and if I'm remembering correctly, I think this is the case, the court used an interesting analogy of publishing a book and a book sitting on a shelf in a library. And they said, the book is published and the book is out there and it's ready for access when it sits on the shelf. The fact that nobody actually opened it and read it doesn't mean that the information in it is not published. I think that was Travelers, but if I'm wrong on the case, I will tell you that there is a case that said exactly that. And again, that's very interesting to me because one, it's not only contrary to lots of other cases that say publication requires actual access, but the case essentially said as soon as it's out there and it's available for someone else to have access, then you've got publication. Very interesting thing in Travelers. Unintentional publication is still publication. A little bit different from one of the cases we looked at earlier, and obviously publication doesn't require third-party access. This is a 2016 case out of the Fourth Circuit, and it is a very broad interpretation of the CGL's coverage CGL's coverage for a cyber breach under coverage B, and quite frankly, as I said earlier, when you read the cases, you kind of, you flip-flop and go back and forth. The Travelers Porter Healthcare case is one that every time I read it, I go, yeah, that seems to be the type of logic that other courts could grasp and latch onto. So this is definitely one to watch as far as setting the tone for how these types of risks might be covered. So thank you for indulging me as I kind of ran through some of the cases. As you can imagine, there are a ton more. But the real takeaway for the CGL is that the cases are all over the place. The analysis and the logic is different depending on what court you're looking at. And quite frankly, I haven't kind of taken a tally sheet, but it feels to me like maybe a 50-50 shot depending on what court you're in, whether the court is going to say the coverage B under a CGL applies or doesn't apply to a hacking event, a liability claim against an insured for a hacking event. Earlier I had mentioned that even though these policies shouldn't be kind of the core of an insurance program for any company, they nonetheless, in some cases, can be tailored. I had talked about endorsements onto the D&O policy, things like that. The CGL, ISO, the insurance services offices that creates the standard CGL policy, has actually introduced several endorsements to address cyber risks, and they go both ways. It's not necessarily a one-way street. The first one deletes coverage for the invasion of privacy offense. Obviously, that's pretty straightforward, and it says we're not going to cover that. The next one excludes coverage for injury or damage except bodily injury arising from access to or disclosure of confidential or personal information. I struggled to think about what type of claim that would respond to. And I hope we don't have anybody from ISO here, and if we do, I apologize. That seemed to me to be a give back with no real substance to it. But if anybody has any experience or knowledge as to what bodily injury might arise, let me know, and I'll change my tune as to the purpose and intent of that. Over the years, I have seen you see ISO and sometimes carriers will provide certain coverages that you scratch your head and you say, really? Is that going to respond to anything Jim talked about at the beginning? Well, no, but nonetheless, it's a give back. And then the 070514, that's similar, but it excludes bodily injury. So some of the things ISO is doing to deal with these types of exposures. Takeaway from this is, when you look at the CGL, recognize that in some cases, they will specifically deal with these types of risks, either through a minor give back or through an express deletion of that coverage. And these are things you have to look at whenever you're considering whether the CGL might respond to these types of risks. The first endorsement up there is one deleting coverage for the invasion of privacy offense, again, altogether. The second one excludes coverage for injury or damage. Oh, wait, I'm sorry, I went to the wrong, there we go. The second one is the buyback liability coverage. Property damage includes loss of electronic data. So that's a give back. That is a potential significant coverage under the GL, where the policy is specifically saying we now recognize that property damage, and remember this is a coverage A issue, not a coverage B issue, that the definition of property damage includes loss of electronic data. And then the one at the bottom is interesting. This is an endorsement. It's specifically a claims-made coverage that can be purchased as an add-on to a CGL, and that's for losses caused by an electronic data incident. And an electronic data incident is pretty broadly defined to include a lot of the types of cyber risks that Jim had talked about and things we see. So to the extent anyone thinks I took an unfair jab at ISO earlier on their bodily injury endorsement, here I'll be their fan, and I will say this is a very good and effective coverage that can be added onto a CGL policy. Recognize that it's written on a claims-made basis, not on an occurrence basis. Most standard CGLs are written on an occurrence basis, but nonetheless, it's an avenue to potentially find additional coverage under a CGL for these types of cyber risks. So with that, just very briefly before I finish, I had said early on that I was going to talk about the different policies where you might find coverage. You're going to hear from Robert and Emily, and they're going to talk about the real meat and potatoes for finding insurance coverage for these types of losses. But what I would say, and I hope it's what I said at the beginning, and somebody told me you're supposed to say things 3 times if you want anyone to remember it. I'll stick with 2. And the second time is saying this: don't ignore all of the standard insurance policies that your company may have in place. Don't ignore those policies as potentially having the ability to do some add-ons, as we saw in the CGL and in the property, to provide a little bit of extra cover for these types of risks. Although the cases are pretty much all over the place, as we talked about very briefly, and I'm not going to say, there's a guarantee here. The fact of the matter is if you are a corporation with a sophisticated insurance program in place, you're probably going to have all these coverages in existence. When a breach comes, don't just stop at the great policies that you're going to hear Robert and Emily talk about. Always look to the other coverages to see if there's any potential availability. And before a breach happens, talk to your broker to see if there's anything you can do with those policies to enhance the coverage through an endorsement, through some sort of change. Perhaps if you're a big enough bear, a manuscript change to the policy to get you a little bit of coverage under those, and to really kind of dovetail, it's probably an overstatement, but to really kind of supplement the true cyber risk policies that Robert and Emily will talk about. So with that, unless there are any questions, Robert, I'm going to turn it over to you.
Well, actually, before we do that, a couple things. One, the say it 3 times rule works for adults. If you have teenage kids like I do, it's like 5 or 6. The second thing is there will be a quiz. We're going to take a break here for about 15 minutes. We're a couple minutes ahead of schedule. Good job, Joel. Apparently we have a question from the from a live streamer. Okay, Joel, come on back up here. It says, in the Portal Healthcare Solutions Travelers example that Joel covered, if the data wasn't reviewed by a third party and that was confirmed, what cost damages is Portal requesting and receiving? Costs to investigate or monitoring costs as a precaution? The example given was a book was published and on shelf, but I would think the insurer would say there's no damage that would fall under CGL. I didn't completely understand the logic. When there's a problem, we typically look to see if the data was accessed by others.
Okay. I think the costs in that case, and am I on? Jim, let me. If I understand the question correctly, it said if the data wasn't reviewed by a third party, what cost damages was Portal requesting and receiving? I think, if I'm remembering correctly, what happened was there were significant costs claimed, in a sense, with defending that claim. So third parties bring an action and they say, okay, here are the claims that I am making. You have published my information and therefore I've suffered damages. But in responding to that, as you can imagine, you still have to hire the lawyer, you have to respond to those claims. I believe we are probably talking more about defense costs and expenses than we were actually talking about compensation to a third party for the loss that I think the question appropriately recognizes may not have existed.
Okay, thank you, Joel. As I was saying before the question came in, we're going to have a quiz afterwards. And here's the question. A data can falls out of an airplane, hits a hiker in the woods, but nobody knows about it, and nobody reads the data. Is there coverage? And with that, let's take a 15-minute break.